Judge Joe Brown's all-new barbecue sauce and seasoning. Justice in the form of flavor.
Law firms will take this as a retainer.
What? It must be a law firm where they hungry as hell. Now you gonna help me with this parole I'm dealing with?
Judge Joe Brown's all-new barbecue sauce and seasoning. Justice in the form of flavor. With one taste of our premium blends of all-natural ingredients, herbs, and spices, you'll fall in love with meat all over again. Judge Joe Brown's all-natural barbecue sauce collection is made up of 2 zesty flavors, original and spicy. There's only one way to bring order back to barbecuing. Just add Judge Joe Brown's all-natural barbecue sauce and seasoning, and you be the judge.
Hi guys, so welcome to episode 2 of Injustice for All. Hi Judge. And today we're going to talk about Donald Trump and the New York case via Judge Merchant. I want to share this because he is scheduled to be sentenced January the 10th, Friday. But Donald Trump did ask SCOTUS, the Supreme Court, to step in and intervene in the hush money sentencing. So President-elect Donald Trump filed an emergency application at the Supreme Court on Wednesday morning, asking the justices to stop the criminal sentencing in his New York hush money case. The judge in that case declined to put the sentencing, scheduled for January 10th, on hold. Trump told the justices that forcing him to prepare for sentencing in the weeks before his inauguration imposes an intolerable, unconstitutional burden on him and undermines the vital national interests.
Okay. May in fact do that. That's interesting, but that's not his strongest approach. However, Mearshon can generate a constitutional crisis when he sets the state of New York against the United States of America. This man has already been declared to be the selection of the Electoral College as constituted for this cycle. He is only awaiting his swearing in. He is the presumptive Chief Executive for the United States, Commander-in-Chief of the Armed Services, and also Chief Diplomatic Officer. So he's also head of the Justice Department is subordinate to him. So if Mearshon, let's say hypothetically, said you're going to be locked up you're hereby sentenced to so-and-so, then what happens is they have to execute, which means they'd have to take him under arrest, which means one state out of the 50 and the rest of the territories and protectorates, which includes Puerto Rico, American Samoa, some other places, would then decide to pit itself against the United States of America, take him into custody, and that would say the U.S. Marshals, the Army, since he's Commander-in-Chief, even though he hasn't been sworn in, he will be. That's going to create a real problem, and that would probably result in an action filed by quite a few states saying that the actions of New York, acting through Mearshon, would be depriving them of their chief executive, and that would go directly to the U.S. Supreme Court. And I can also see them trying to take him into custody in the Marine Corps or the Secret Service saying, no, you don't. And what are you going to do if you try? You have to go through us, which isn't going to work out well for anyone. Additionally, I think Mearshon might get caught up in a criminal conspiracy here on the federal level if the incoming administration dots the I's, crosses the T's in the appointment of special counsel. Also, there is this matter of him remaining on the case, which is an egregious ethical violation because his wife had a fundamental interest in the outcome, and so did his daughter, which involved, I think, what was it, $28 million in funds she was managing to see that he did not get in, which, as any sane jurist would know, any lawyer ought to know, is immediate grounds to get out of the case and recuse yourself because you've got no business being there, because it generates the appearance of an impropriety. Next thing, it looks suspiciously like lawfare, because in the totality of the case, which essentially was paying hush money to hush up the commission of a crime, there was no crime proven, and in spite of numerous and frequent requests on behalf of the defense, the judge refused to charge the jury with the responsibility of finding beyond a reasonable doubt that there was at least probable cause that a specific crime had been committed that was supposedly hushed. And in addition, when hush money is paid out to prevent embarrassment for whatever reason, or to get someone to do something he otherwise would not do, or refrain from doing something he otherwise would not refrain from doing, that's blackmail. That's a felony, and they should have charged Stormy Daniels with that, arguably. Now, the thing of it is her testimony was what you call testimonial immunity in its nature, which is interesting, because if somebody testifies and their testimony leads to something independently, they're still subject to prosecution for that, but they get immunity only for what they specifically testified to. So you get this shotgun approach to testimony where the witness is this blah, 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 at great length. And the more she says, the more immunity spreads. So it looks like perhaps the prosecution, Bragg, blackmailed Stormy Daniels into, we'll prosecute you for felony blackmail if you don't go along with being a witness for us, and that's why the testimony looks so peculiar. And there's an interesting thing about American law. If the judge doesn't instruct the jury with the proper law, the conviction is completely invalid. So that is fundamental. And the fact that he may have had various meetings also ties him in as a minor actor in what could be a conspiracy, which right now has set a horrible precedent, because you've got the specter of Kamala Harris, who had the meetings with the parties involved, Bragg, perhaps Fox out of Illinois as Chicago state's attorney, certainly Fani Willis down in Fulton County, Smith, the so-called special prosecutor, whom we find was not properly appointed, the just resigning U.S. attorney in New York for that district. And others would be Letitia James, who purportedly met up with Kamala Harris in D.C. And depending upon what Wade said, and I imagine he's trying to get himself into a situation where he will be allowed to plead guilty to an offense that has a low cap on it. You can't plea bargain to sentencing, or well, to your sentence. In federal courts, you only plea bargain as to what crime you plead guilty to, and it's talking about a minimum cap or maximum cap that's not great. So you don't risk too much time in jail, which would be exclusively up to the judge applying federal guidelines. So I imagine Wade toned up his voice real well, and he sang nicely, and he's implicated a lot of people. And the thing about a conspiracy that's interesting is you can criminally conspire to do a legal act in a legal fashion. So if they just limited it to letting a grand jury establishing probable cause, that's one thing. But if they discussed how to thwart Trump in any fashion, that becomes a conspiracy, and everything they did becomes part of a criminal conspiracy. And the interesting thing about it is unlike in a regular case that's charging somebody being a principal in the commission of a crime or an accessory before, after, or during the commission of the offense, what winds up happening is if any one person commits any one act in furtherance of the conspiracy, and anybody else who was in agreement with the object of the conspiracy, in this case, to thwart Trump's efforts to become president number 47, then that becomes a conspiracy, and anything any of them say or any evidence against any one of them can be introduced against all of them, which is a very nasty position to be in if you have to defend it. Now, what is alleged under that theory, or would be alleged, is so egregious that it has to be deterred so nobody does it in the future, because the foundation that this Democratic Party effort put in place could be turned in a decade against them, and it sets a precedent in America where you can get around the Bill of Rights, which was set up specifically to prevent the judicial processes of the United States from being used for political oppression. So we've got a bad thing here, and I don't care whether it looks like somebody's going to be able to scream, retaliation, retaliation. There needs to be an appropriately appointed special counsel or for prosecution or a staff, and they need to stamp this out as a deterrent to anyone who's contemplating the doing of such a thing in the future. So I'm looking forward to it because it was just absolutely horrible. Now, Mearshon's wife was interested in the outcome. His daughter controlled what was it, $28 million in funds to ensure the outcome. And that is very bad. So somebody needs to be subject to deterrents and say, oh, wow, they really came down on some people about this. I'm not going to do this in the future. So those are the kind of considerations that are coming into play if Mearshon goes ahead with this Friday sentencing. Really, he ought to have good sense and back out of it and say, in due consideration for the defense motion to dismiss the charges, the court has reconsidered those motions and will grant them and let the state take this up on appeal as to whether or not that was appropriate, and I don't think they would. So
My
it's
question,
a real live wowie whoopee.
so January 10th, the sentencing, he put,
In other words, what's he going to do? Is he going to put him on probation? That would mean restriction of the chief executive of the United States of America. No way. Is he going to put him in jail? No way, ain't going to happen, because
no, he said he
the
wasn't.
Secret Service can guard him. Is he going to restrict him to house arrest? So which house are you talking about, New York or up in Washington, D.C.? And you mean to tell me that he can't fulfill his duty as commander-in-chief and do like every other chief executive who's so disposed, visit the troops around the world? You mean you're going to say he's confined without my permission, meaning Mearshon, he can't travel overseas and after, refrain from dealing with foreign heads of state, ambassadors, diplomats, and can't conduct the diplomatic business of the United States? No way, no how.
So my question, so he picked January the 10th to sentence him. Now, the last quarter on 2024, he put that case on hold. Did he not? Judge Merchant?
Yeah, I've done this for longer than he has.
No. So this is what I'm trying to connect here. He put it on hold because it looked like he was going to drop it, right? And then the election was coming up, so he put it on hold. I guess
he wanted to see what the outcome was going to do, so he could squirm around and see what he was going to do. As I said, his soundest move to avoid prosecution, discipline, loss of office because of the egregious wrong that he's done so far should be to indicate the court is reconsidering the motion to dismiss and will grant it.
Right. So he picked January 10th, 7 days before the inauguration. Is it 7 days?
No, it's longer than that.
He's being inaugurated on the 15th. No, on the 20th. On the 20th. 10 days.
Yeah.
10 days before the inauguration. Clearly, and I said this before, this is something that the Democrats want to have a soundbite for the next 4 years. Oh, we have a convicted president. We have a convicted president. That's one. And two, I believe he is under the thumb of these Democrat leaders, Chuck Schumer, Hakeem Jeffries, right? And these are all Democrats.
If you can prove that, all of it.
Let me finish.
Conspiracy.
I know it's alleged. This is me, my conspiracy.
No, I mean that's serious business. And Fannie Willis opened all of this up when she got her dumb behind up on the witness stand and testified in that.
Him sentencing Trump on January 10th, and if this man is doing it by the orders of the Democrat Party, that will be corruption, right? So this is a hypothetical that I'm bringing to the table with you. Has there ever been such a time in our legal history where judges have been found guilty of taking orders and instructions from politicians, powerful politicians, to hinder a judgment against someone else or to convict someone else? Has that ever happened?
No, but well, yeah, bribery and stuff like that on a minor level. But reason I apologize for cutting you off, but it really is irrelevant, because what happens is, in that worst case scenario that you paint, the increased liability does not go to Mershon, it goes to the individuals in question. I think they've already got what they need to set up a conspiracy, a criminal conspiracy. I think they can connect Mershon to it. And all of the rest of the above need only be proven that the individuals you name had some input into the decision made to accomplish the ends of that conspiracy, that is, to thwart, prevent, or make more difficult the ascension of Donald Trump as president, the 47th president of the United States. So all you have to do is prove any involvement in that agreement, and you can arguably get somebody involved in a criminal conspiracy. That would make absolutely no difference as far as Mershon is concerned. It would just implicate the other individuals to their detriment in the conspiracy. Now, what's going on is something that's very bad, that this idiot that is the current United States president, Joe Biden, along with Eastland and Byrd, got in place about 40 years ago, amending the federal rules of evidence when it comes to criminal procedure. And what happens is that it allows a prosecutor, a federal prosecutor, to bring basically unsubstantiated charges against someone with no penalty, no sanctions, for the specific purpose of disabling them doing something that they otherwise would be able to do. It's a travesty, and it's 40-some years overdue and being addressed. And this is one of the consequences that 40-some years ago, when it came into effect and I was practicing federal criminal defense work, I said it was going to eventually hit the fan, and it has. I don't think there's ever been an instance in American history where the judiciary and the criminal justice system have been involved in something so egregiously stupid as this. It's just absolutely amazing. And it all started, we saw it, when Fannie got her butt up there with that snake charm stuff with her head, hand on hip, and her dress on backwards, American pen upside down, and she got up there, and Judge McAfee said, well, ma'am, we're trying to decide whether anyone could call someone from your office. But I decided I was going to testify. And I said then she would pull off the worst idiot move I have ever been experienced 2.5 centuries of being in this law business when it came to a stupid move with the Fifth Amendment and self-incrimination. And all of this stuff got put in play when Wade got sucked up into this mess, and he wound up being subpoenaed in front of a congressional committee, and he's given testimony under oath that is now on the record and recorded and can be used in prosecution, and has probably resulted in some kind of arrangements made in return for his testimony to implicate all of the people we've been talking about in the process. And anybody that has any agreement, howsoever slight, in the outcome, i.e., thwarting what Donald Trump was trying to do, that did result in him getting elected, that is a conspiracy. It's a felony. And if any one person involved in this web did anything in furtherance of that, then you've got a conspiracy that all of them can be found guilty of. And you have certainly what happened down in Fulton County, Georgia, certainly what happened with Bragg in New York, certainly what has happened with Smith down in Florida as special counsel on the federal level, certainly to an extent when you consider the machinations of Jesse Smollett up in Chicago and what was going on to try and improve Kamala Harris's chances in the election process. And it's absolutely fitful what happens. And from that, I'd expand to something else to show you the ignorance that has led to ethical aggressions. The Democratic Party is trying to say, look at Kamala Harris. She acted with dignity and she conceded that Donald Trump won. No, that was an egregious ethical violation. Her name was mentioned. Her name was immediately subject to close scrutiny because she was the victor's opposition. So she had no business putting herself in a position where she could have determined some other outcome. She should have recused herself from the entire process and allowed it to devolve upon a temporary president pro tem of the Senate. And that would have been by letting the minority whip or minority leader, a Democrat, or just allowing that would be a Democrat in the Senate, to preside over the proceedings, so she did not get a chance to, did not have to mention her own name and potentially evoke the Confidence in Elections Act of 1877. And I've said this over and over again. That act directs the Vice President of the United States, upon his finding or her finding that there is a widespread discontent or lack of confidence in the outcome of the election, to call for the appointment of a special 15-person commission, 5 from the House, 5 from the Senate, and 5 from the Supreme Court, to investigate the outcome of the election for the Electoral College, taking a minimum of 10 days or such extra time as is necessary. So keeping herself in this loop where she had the authority was a total impropriety, and she should have recused herself. It was a horrible indiscretion. So she apparently did the same thing on a somewhat minor scale that Fannie Willis did, which is, why in the devil did you put yourself in this loop that led to this mess and failed to understand the ethical considerations?
Well, I want to share this because, yes, I laid out my conspiracy of our justices being linked with politicians. It is unethical to do that. But when you have this judge here, Trump wants to erase his guilty verdict, but this is MSNBC. Judge Merchant has a plan to stop him. Judge Juan Merchant understands that jury verdicts matter. And in this case, the verdict matters more than the evidence.
Stop right there. That's bullshit.
Mm-hmm.
Judge in most states considers a 13th juror, and if the jury verdict is inappropriate or unjust, he can effectively act as the 13th juror. They call it the 13th juror rule, and deadlock the jury and make it a mistrial. The point is, the main error in this thing is his. Now, the point is that he can have all of these ambitions, but he should not be readable as having a plan. He should be a neutral person. In other words, you got a baseball game. The umpire is standing behind the plate, right? And the pitcher is on the mound. There's a batter up at the plate, and there's a catcher. The pitcher throws the ball. The umpire is not supposed to know what the pitch is. He's just supposed to call it as to whether it's a ball or a strike. You see, it's what you just posited would be as bad as the umpire having a plan to be able to maximize the number of strikeouts for the home team.
Mm-hmm.
See, he's supposed to be neutral. He's the umpire. He's not supposed to have a plan.
Right.
And his thing is he needs to take the opportunity to stand in and say the court has reconsidered the motion and will grant it.
So this is where we're at now. So I want to ask you, what do you think the Supreme Court is going to do with Trump asking the Supreme Court to intervene?
Not a damn. They're not going to do anything against him, but the case is not right. See, a lot of people don't understand this. What the court is being asked for right now is effectively injunctive relief. They're not going to do that. They're going to wait to see what actually happens and then rule on the outcome, because right now they would be depriving Mearshon of the opportunity to say the court will declare that in the interest of justice, this verdict will be set aside. The court acknowledges its failure to properly instruct the jury. You see, the rule in law is to give the court the opportunity to correct its own errors. If it does not, then the appellate courts will step in. And Mearshon still has an opportunity to correct his error, plain error on the record. One, failing to recuse, and two, totally inappropriate instructions to the jury. And by the way, those
I don't know. It only does it for you. It doesn't do it for me.
I did it on another show today. I was telling you, and the balloons went up too.
Yeah, I don't know. It always does it for you.
When I did it with Drew, the balloons went up.
Yeah, I don't know. It's always on your end. The balloons go up. Okay, so you mean to tell me that the Supreme Court is not going to issue a decision with Donald Trump? I think they
not until Mearshon acts. In other words, see, when we convene Friday, January 10th, Mearshon may say, do just what I said. The court is reconsidered. And in light of all the circumstances, it will find that it inappropriately charged the jury. Therefore, the verdict is invalid, and the court will set the conviction aside. That leaves it up to the prosecution for the state of New York as to whether they will attempt to proceed, which brings all of that other stuff into play. So the rule is give the trial court the chance to correct its own errors. So if he does not correct those errors and enters an order accordingly, then you start evoking the appellate process. See, in other words, I've had it happen where I've done that. I've looked at, saw the trial, was there the whole time, and we set this thing for a motion for new trial, or you could put sentencing first, then the motion for new trial, or reverse that. Usually it's you deal with the sentencing first, then the motion for new trial. And I, sitting as the court, had the option of exercising the 13th juror function and saying the court itself does not agree with the verdict under the circumstances and sets the verdict aside. See, at this point, we have a verdict, not a conviction. There is a difference. The conviction does not occur until sentencing has occurred, until the appellate process is exhausted. At this point, since we don't even have sentencing and the opportunity for the court to correct itself is not exhausted itself, we just have a verdict which the court can reject. It still has the option to reject.
Okay, so it says here, Judge Juan Merchant's decision to set President-elect Donald Trump's sentencing for Friday, just 10 days before the inauguration, caught a lot of people by surprise. Judge Merchant indicated up front that he wasn't inclined to sentence Trump to time in prison, and indeed that he was leaning towards an unconditional discharge, meaning Trump wouldn't have to pay a fine or be supervised by a probation officer. He will walk away a free man with no further obligations to the court.
That would perhaps moot the whole issue. But see, that's exactly what I'm talking about and why the Supreme
But why sentence him?
Well, in other words, that's his way of saving face. And some people, they're political animals. He's in his 80s, so there's not much future for things beyond where he is. So he just may be out of a sense of pride and ego attempting to save.
I gave my conspiracy theory on why.
You have to prove it.
Yeah.
And the point is that right now, it hasn't gotten there. But it might get there if you can show there's any kind of agreement, however casual, to select an outcome. Now, he may, and this is what I said, he may Friday bail on this and indicate he has no part of what suspiciously looks like a conspiracy. So this is his opportunity to save face.
So it says here, Judge Merchant's critics had two main questions. Wouldn't this punishment amount to a slap on the wrist, undermining the rule of law? And why couldn't the judge wait and leave the sentencing hanging over Trump's head until after he left office in 4 years, when his presidential immunity no longer applied?
Because there's a time limit that's probably in effect as to when he can do the sentencing. There has been a jury verdict. There have been continuous proceedings. And for him to continue them indefinitely without an indication on the record that, and he could get away with this, quote, if there are no further problems on this date, 4 years and 1 month hence, the court intends to dismiss these charges. But then that would set conditions upon him. And you can't, as a state trial judge, set conditions on the operation of the whole United States government. So the chief executive officer for the United States government is the president of the United States. So if Mearshon imposes any conditions at all on Donald Trump, he will be imposing conditions on the United States of America as a whole, for all 360 million people, for American Samoa, etc., Puerto Rico, all of the 50 states, the Canal Zone, every military base, naval base, Air Force base, Marine Corps contingent in the United States or operating for the United States. He doesn't have that authority. That's way over his pay grade.
So this is the application that Donald Trump has submitted to the Supreme Court of the United States. In the Supreme Court of the United States, President Donald J. Trump, applicant versus people of the state of New York, Alvin L. Braggs, and acting Justice Juan M. Merchant. So I guess he submits an application for a stay of criminal proceedings in the Supreme Court of New York County, New York, pending the resolution of President Trump's interlocutory appeal.
Interlocutory. In other words, interlocutory means you lock up everything until this is resolved.
Interlocutory appeal on presidential immunity. But you're saying
It isn't ripe yet because he hasn't done anything to impinge the presidential immunity. What his team has effectively asked for is injunctive relief. In other words, before anything happens, to enjoin or prohibit the doing of the wrong. What the Supreme Court did is it properly ruled saying, well, he might not do wrong. And if he does, we can immediately step in, but he may on his own correct his own errors and say the court charged the jury incorrectly. The court has reconsidered what has been filed so far and will grant the requested relief.
Okay, so what Trump is doing, he's just getting ahead of it because, like you said, when he don't have to show up on Friday, but Friday on January the 10th, whatever Judge Juan Merchant says, he may say, okay, I'm done with it. Just get rid of.
If he does anything that impacts Trump's liberty, his ability to act freely as chief executive of the United States will potentially engender a constitutional crisis because.
But he said he's not going to issue a probation officer.
No. Anything he does that impacts the president that requires that he answer to him says something along these lines. The indictment reads, I read it, it says, the people of the state of New York versus Donald Trump, et cetera, et cetera, et cetera. So what that means is that the people of New York, the state of New York, have put themselves in a position where acting through Mirshan, they are attempting to dictate something to the United States government, and they cannot do that. No one state can dictate to the whole federal government what is to happen because there are 49 other co-equal states.
All right. One more thing.
And by the way, I find it astonishing that the newspapers do not have anybody with very extensive experience in real life constitutional law in a criminal environment or landscape that has commented on this. They have their so-called experts, but I can't find a single one of them that has extensive trial experience, if any at all. So I call the people that they have consulted with essentially rookies. They haven't been involved in the profession very long from my perspective. So
it says here, this is something else. And this is the last thing I'm going to put on the table. Justin, Joe Biden is still considering preemptive pardons for Liz Cheney and Anthony Fauci.
And well, go for it. Go ahead.
Biden wants his legacy to consist of giving a free pass to a man whose thirst for power cost the lives of hundreds and thousands of Americans, as well as a woman who attempted to carry out a political hit job for him. Biden is beyond. So this is somebody's own.
I'm not worried about Fauci. See, what you're talking about is allegedly incompetence. Incompetence is not criminal. Mm-hmm. It's intentional effort to violate the law. And frankly, nobody knew a damn thing about COVID-19, SARS-CoV-2, because we have had SARS-CoV-1 in 1980, 82, and then we had SARS-CoV-1A that occurred in 1988. That was known to have caused problems around the world, not too much in America, and then SARS-CoV-2. And they're all COVID related, or not COVID, but they're related to the same thing that causes the common cold. So that's 7 episodes of COVID, and 4 of them involve the common cold. So it's a new thing because you remember that there was no cure for the common cold. The other thing is there's a large number of people still around who went through the NOM. They went through World War II, a very few still a number that went through the Korean War and a whole lot that went through the polio epidemics. And when they had the polio epidemics and they had the shots before they got the sugar cube with the pink dot, they advertised that out of every 100,000 people, so many are going to get sick and die from this, but we'll save a whole lot. And people will say, hey, we've been in 3 wars, we can afford the risk. Now everybody risk adverse, so they're all upset about it. I make no judgment on whether or not there was an intrusion.
I'm going to move away from that.
I know, but
the reason
I bring this up is if you're going to go say you need to pardon Fauci, you have to understand that just like anything else, what you have to figure out, what are they going to charge him with that has absolutely any chance of resulting in a conviction? And I'm not saying that as something I might have overlooked, but I can't see any criminal act coming out of this when what he did was within his authority. He did not abuse it. He misused it perhaps due to misjudgment, but I can't see anything that would subject him to criminal prosecution. You can be turned out of office, you can be discredited, all kinds of other things, maybe civilly liable, but not criminally prosecuted for making a mistake. You see, that's the difference.
Okay, so this is why I brought that up, because when we talk about preemptive pardons, we spoke about that as far as Fannie Willis. Will he give Fannie Willis a preemptive pardon?
Well, see, the problem with Fannie Willis is she still got problems with the state of Georgia, which the president cannot pardon. So it's a question of what's going to go on. And he'd have to do something like have a preemptive blanket pardon for everybody for criminal conspiracy. And see, the devastating political results of that would be a disaster for the Democratic Party. Your Speaker of the House, all of these VIP Democrats, prosecution from Illinois, prosecution from New York, prosecution on the federal level, they're getting pardoned for being part of a conspiracy. In other words, what would that do? You guys had to be pardoned. That they'd never get rid of that, at least not in a number of decades.
It'll be a nasty stain on that party.
A nasty stain.
So apparently a lot of these people, a lot of these pawns, right, that were doing your dirty work to try to keep Trump out of the White House, they may have to just get thrown under the bus or just fed to the wolves.
And see, the other thing is he'd have to name each individual in question. Now, Barack Obama pardoned 23 British petroleum executives for that Gulf oil rig blowout that caused so many billions of dollars of damage. And for negligence and a number of failures to comply with federal law, but he pardoned them. They never showed up for arraignment, but there is that onus on them, and their private world of business is not going to hurt them. But if they had to operate in the environment like, hey, I don't want you, you had to be pardoned for what you did wrong. And see, you can say you have no criminal liability, but what kind of damage does that do to the Democratic Party? And see, That's what they're scared of. This senile somebody that isn't half aware of a lot of stuff. It's got nothing to do with his age. It's just his individual circumstances. He's going to commit the Democratic Party to looking like a bunch of idiots by pardoning them. So that's nice, but what is it? There must be sacrifices made. So maybe for the Democratic Party, the best interest for them is let these other folk hang. They're scapegoats who aren't really scapegoats.
Right. And thank you for mentioning Obama, because so in conclusion of episode 2 of Injustice for All, I wanted to do this, have it drop every Thursday. And then knowing me, I may switch our live streams to Thursday and then drop this Injustice for All episodes on Monday. Either way, Injustice for All right now, every Thursday, where Judge talks about injustices in our criminal justice system, the Constitution, the law, political science. And when you brought up President Barack Obama pardoned all of those heads of the oil companies, right, that had that oil spill in the Gulf.
British Petroleum.
Huh?
British Petroleum. And see, there's another little part.
Don't go into details.
No, I'm not. And this is the bad part, that actually would subject him to proceedings to impeach.
Can you say before episode 3?
You know what that was?
What? I want you to say this.
No. I mean, very brief.
No. I want to do a show on the whole thing. So just hold it.
Give the tease. You know what the tease is?
What?
His trust fund was a major investor.
That's not a tease. Well, that's the bite.
Yeah, but that just sets the stage. His trust fund, his father, who generated the fortune that he inherited, were major investors in British Petroleum.
You just gave us the bite.
No, that's the bite. But I'm talking about the.
Oh, that's not the meat of it. That's all.
Not the meat. That's just like he's charged with murder. Somebody's charged with murder. Well, what are the allegations? Did somebody hang somebody from a flagpole, throw them off of a building, throw them out of an airplane, or what?
Oh, okay. So episode 3, that is going to be the topic. So thank you guys for tuning in to another episode of Injustice for All with Judge Joe Brown.
See, one last thing. If you're really conversant with the law, learned and experienced in the law, and perhaps wise in the ways of the world, which perhaps I am, maybe I'm not, what winds up happening is you get insights to things that become obvious to you that allow you to skip intervening steps. Like, in other words, first-year law students focus on the difference between somebody getting a fractured or smashed leg and somebody getting a smashed finger. They think because of the degree of the injury and the pain, there is a difference. It may not. The principle of law may be exactly the same. So you have first-year law students debating the severity of the injury. If you are the professor for torts, you can say, oh, no, wait a minute. That has absolutely nothing to do with it. But professor, there was just a minor broken finger. No, that has nothing to do with it. It's the issue of accountability for actions that led to the injury. The injury and the nature of the injury have to do with the damages. We're talking about liability here. So the professor cuts it off. Why? So that the law students don't make the mistake of wasting all this time talking about an irrelevancy. It sounds arrogant, but it's like, that's why you have the expertise. That's why you have the doctorate of law. That's why you are a member of the bar. That's why you have all of these trial experiences, appeals, and research under your belt after a certain point in time that you can bring to bear on these questions and say, we don't need to go there. That's a waste of time, because we need to jump from A down here to part F, because all of this other stuff is preliminary.
Okay.